We're going to start the first of two panels, and I want to thank all of our panelists for sharing their insights with the committee today. This is really where we dig into much of the meat of our recommendations, so thank you for joining us. As is our custom, each panelist will have 5 minutes to make opening remarks. Really, really, really please try to keep it to 5 minutes, and then we'll reserve the rest of the time for Q&A, which I think is often the most productive time. So, for our first panel is about self-defense for survivors of IPV, particularly when they're accused of killing their abusers. Our panelists are David Andreessen, is that pronounced correctly?
That's correct, thank you.
Yeah, staff attorney for the California Appellate Project. Wendy Howard. Ms. Howard, are you there?
I'm here.
Hi.
Hi there.
Elizabeth Sheehy.
Mm-hmm.
Am I pronouncing that correctly?
Yeah, perfect.
Professor Emeritus at the University of Ottawa, and Sandra Babcock, Clinical Professor of International Human Rights at Cornell Law School and Faculty Director of the Center on the Death Penalty Worldwide. Professor Babcock, I just have to get you started. Any relationship to Barbara Beck? Okay.
She's great, but unfortunately, no.
Okay. All right. With that introduction, Mr. Andreessen, can you kick us off?
Sure, thank you. And I'll keep my remarks very brief. I've reviewed the staff memo and heard the earlier presentations, and they very much dovetail with the experiences I've seen, as self-defense cases play out in real life. Particularly, it's the eminence requirement for self-defense is really a very poor fit for these IVP cases, and the fear alone doctrine likewise gets to this whole imperfect victim situation, as the self-defense issues don't generally arise in a vacuum, but there's a lot of complexities, and it can make it very difficult for survivors to make use of these defenses. The only other thing I'd add is that any discussion of self-defense in homicide cases generally, I think, would be incomplete without getting into voluntary manslaughter. As practically speaking, in trials where self-defense is raised, frequently it's not just a question of is it murder or is it self-defense. There's usually or frequently a middle ground of voluntary manslaughter, which a lot of times may fit the facts better. It applies to a wider range of provocatory conduct than self-defense might, and it gives jurors a way to not have this all or nothing choice. Voluntary manslaughter, particularly heat of passion voluntary manslaughter, is an extremely poor fit for these IVP situations. It's maybe one of the most gendered doctrines in all of criminal law, and really doesn't track with a lot of the experiences of women, especially, who are in these situations and kill, maybe not with a complete excuse, but in situations that should definitely be mitigated to something below murder. And really, that's all I have to say right now. Thank you.
Thank you very much. Ms. Howard?
Okay, so my name is Wendy Howard. I'm a mother, a survivor, and I was nearly sentenced to life in prison for protecting myself. The man who survived was the father of my child. I left after years of abuse documented in police reports, court filings, and medical records. But because we shared a child, he was still in my life. I found a photo, his hand on my daughter's chest. I reported it immediately, and when police arrived, he was driving up the street with the police behind him. He lived 3 doors away. They pulled into my driveway. At the station, I told officers he was calling and would ask why they came. They told me to answer, to lie, to act natural. I was expected to keep acting natural to the man I had just reported for abusing my daughter. A few days later, he called to ask if his grandson could come over and play, something he'd done before. I said yes, trying to follow police advice. But I had a feeling he was checking in, trying to see what I knew. I'd had a legally owned firearm for over 20 years. I didn't carry it with intention. I carried it because I was afraid. I was home alone with my daughter, the one he had just molested, along with my younger children and grandchildren. I knew what he was capable of, and I was not prepared. I was not going to not be prepared. I felt more dangerous than being ready to protect all of us if I had to. I stood near the front of the quad he arrived on. He mentioned taking our daughter overnight, and I said, she's not going anywhere with you, and this is why. And I showed him the photo that I had. He looked at the photo, called our daughter a lying bitch, and saw that unmistakable shift His eyes went black, the look every survivor knows, the one that means violence is moments away. Then he came at me fast on the ATV. I believed I was about to be killed. I fired to protect myself and my children. He was still alive when officers arrived. He fought them for over 20 minutes before leaving in an ambulance. I was the one arrested, charged with first-degree murder. The lead detective admitted under oath he never investigated my abuse claims. He said his partner did, but his partner testified he hadn't either. No one verified my truth before they tried to send me away for life. In court, while two of my daughters, his abuse victims, sat just feet away, the DA called it mere allegations and said we were trying to smear the victim. That's what they called years of abuse, medical records, restraining orders, sworn testimony. They dismissed it all until the evidence of abuse became too much to ignore. They didn't drop the charges, they reinvented them. We had an expert witness ready to explain the science behind trauma, but I was told using them would only open a door to unrelated personal history, as if surviving made me less believable. That's what it's like when you're a survivor on trial. You're not defending a moment, you're defending your entire existence. The jury couldn't convict, it ended in a mistrial, but the DA wouldn't let it go. They were ready to put all of us who survived this man's abuse through another difficult, re-traumatizing trial. I took a plea, voluntary manslaughter. I served 99 days in jail and a year on probation. I carry felony conviction because I survived. Even basic things like staying involved in my kids' school and sports became uncertain. I believe the justice system would protect me, and it didn't. At trial, the DA told the jury that my description of his eyes going dark, that shift right before he attacked, was fiction, something I had made up. But I know what I saw. Survivors often become attuned to subtle changes, a look, a tone, a posture, a signal of imminent danger. It's a form of hypervigilance, a survival instinct honed over time. They knew better, and they still dismissed it. During jury selection, they removed anyone who actually understood domestic violence. If the justice system is supposed to find the truth, why silence the people who know it the best? Years of abuse left me with PTSD and chronic illness. I live on Social Security because I can't work the way I used to. This case cost my family well over $120,000, still owing thousands of dollars. I was denied victims' compensation because I had charges against me. His family, the ones defending an abuser, were given court advocates to sit beside them, to make them look sympathetic to the jury. My daughter, the one who had been harmed, who lost both of her parents in a single traumatic moment, who saw part of what happened, got nothing. No one to guide her through it, no counselor, no advocate, not a single person to help her cope. She sat in court, made to testify against the mother who protected her. The system was ready to send me away for life. And if I hadn't protected her, would I have been charged for failing to? Women are being prosecuted for surviving. And if the system doesn't change, more families will be shattered. More kids will lose their mothers, not to violence, but to the courtroom. The system is broken, and it's the already abused women, children, families like mine who continue to pay the price. Thank you.
Wow. Thank you for sharing. Truly. You okay? It brings us all home. We can talk about all the data and the whatnot and the statutes, but it really does bring it home. So thank you for sharing. Professor Sheehy.
Thank you for inviting me to participate in this really interesting law reform process. And thank you to Rick for briefing me. And thank you, Wendy, for making it really real and immediate in terms of the urgency of these issues. Our country, Canada, reformed self-defense in 2013. What it did is it took multiple criminal law self-defense provisions, one for self-defense when the accused was the initiator of the conflict, and also defense of others, such as a child, and put them all into one streamlined, simplified self-defense section. Self-defense now requires that the accused create an evidentiary basis for her subjective belief on reasonable grounds that force or the threat of force was used against her or another person. B, she had to have acted with a subjective purpose of protecting herself or another. And C, that her act in response was reasonable. The next section goes on to define reasonableness by reference to a non-exclusive list of considerations. For example, the nature of the force threatened, whether it was imminent, the size, strength of the parties, past violence, whether there were other means to avoid the threat, and so on. So it's a non-exclusive list of considerations. If there's enough evidence to put these three criteria at issue, the burden then shifts to the prosecution to disprove at least one of those three elements in order to refute self-defense. This new law poses some advantages for abused women who use violence against an abuser. It applies not only to homicide or causing grievous bodily harm, but to any crime committed with a defensive purpose. So, for example, pointing a firearm, lesser assaults, or even attempting to hire a third party to harm the abuser. It applies when the accused is defending anyone, not just herself or her kids, but her friend, her sister, her parents, anyone who's, and many of these people are in fact targeted by abusers. It makes questions like imminence and the availability of other options considerations for reasonableness rather than hard-lined legal requirements. The only appellate court to consider our 2013 law was the Alberta Court of Appeal in 2022 in a case called R.V. Naslund. And the majority in that case was clear that self-defense is theoretically available even to a woman who kills a sleeping man. It would be a question for the jury. So it's not illegal. It would not be legally ruled out. It would be a question of reasonableness for the jury to consider in light of all the other evidence. And finally, it refers broadly to the circumstances of the accused and the act, which permits consideration of expert evidence, for example, regarding the availability of police protection or the risk of femicide if the accused were to attempt to leave the relationship. Our law does have some limitations. As far as I know, there's still no decision of a woman who killed an unconscious man being acquitted. And in fact, some judges adjudicating on this new form of self-defense have emphasized imminence as an important consideration, which is really a shame because our law before reform never used the word imminent. And so this is actually potentially a negative thing for our law, maybe not for your law, but for our law, it's actually negative to now refer to imminence as a consideration. We still also have a mandatory life sentence for murder with parole ineligibility starting at 25 years if the woman is convicted of first-degree murder. And so that means most abused women are propelled to enter a guilty plea to manslaughter to avoid a trial, to avoid the prospect of a life sentence with that kind of parole ineligibility. So in fact, self-defense doesn't get argued all that often because women abandon it and, facing the threat or the risk of a conviction for murder. Our law also could be clearer about the relevance of objective social science evidence about the barriers for women who attempt to escape intimate partner violence. Our law also has no obligation or resources committed to investigate its impact on abused women who kill. And that's really a shame because it's not something an ordinary researcher can do without a research grant. And that's because, of course, most of these cases, if they're jury trials, there is no reported decision, only if it's appealed or if there's a sentencing issue that gets appealed. So it actually takes a research grant to try to get trial transcripts and, it's unfortunate. I did a big piece of research for the period 1990 to 2005. We had actually a pretty darn good record for women who go to trial in terms of acquittal. But post-reform, I have no idea. I don't have that research grant. Anyway, that's all I have to say for the moment.
Thank you. That's very helpful. I'm very curious to hear a little bit more about the Canadian system here. Professor Babica.
Hi, everybody. Good morning. It's such an honor to be able to speak to you all. I've done a little bit of research on your bios and a lot of the work that you've done, and really admire the work that you're doing now and have done in the past. And thank you to Mr. Owen for inviting me. So I support everything that you're doing, and I want to inject a different angle that you might want to consider. when you recommend these legislative reforms, and that is the intersection of gender bias and the way that women are treated in the criminal legal system, particularly by prosecutors, and how that intersects with the way that their self-defense claims are weighed by jurors and by judges. I run a project that examines right now, my research is focused on the prevalence of gender bias in the cases of women facing the death penalty across the United States. We do have an NSF grant, which I dearly hope will not be taken away from us, to look specifically at the prevalence of gender bias in women's capital cases across the board, which is the first ever effort to try to examine how this is a systemic issue and not just something that comes up in isolated cases like that of Brittany Collins, a case that you all know about. We also do training. My organization, the Center on the Death Penalty Worldwide, has published the first guide for defense teams defending women and gender diverse clients, particularly trans clients. And we are constantly doing trainings because what we have found is that gender bias is so normalized and so under-recognized as a systemic problem in the criminal legal system. So what we have found so far in the way that this relates to the work that you're doing, because of course, gender bias spans a whole range of criminal cases and not just self-defense cases. But with respect to self-defense, what we see is that gendered stereotypes and tropes are weaponized by the prosecution to undercut women's claims of self-defense and of victimization. To give you a very clear example, what we see is that women are often sex shamed, and this often applies to women who are in intimate relationships where they have alleged that they are victim survivors of intimate partner violence. And what we see is that when that evidence is introduced, and you're all, I'm sure, very familiar with the trope of the perfect victim and how prosecutors weaponize arguments like she didn't leave, she didn't call the police, so therefore it must not have been that bad. In addition to that, and I would argue that those tropes of the perfect victim are also a form of gender bias. But in addition to that, they will often hypersexualize the woman. So there's a case in California right now of a woman on death row. Her co-defendant, so this is not a self-defense case. She did not kill her abuser. She was a co-defendant in a case involving the deaths of others. Her co-defendant, however, was her abusive intimate partner. She met him when she was a child. He was decades older than she was. He attempted to kill her. He burned her with a cigarette. He strangled her. He raped her. And all of this evidence was not disputed. What the prosecutor said was that she held the power in the relationship because her abuser couldn't get an erection and she needed her sex. This is not unusual. We also see that women are demonized for their failure to comport with perceived norms of gendered behavior. So women who aren't perfect mothers. Brittany Collins's case is a really good example of that. But there are myriad other cases. Women as scheming manipulators, women who are, there's a lot of figurative and metaphorical language that is deployed to analogize women to Eve, to the original sin. And this is something that I think has been ignored to an extent that is truly shocking, because when you read these transcripts, you ask yourself, when was this case tried? It must have been in the 1950s. And no, it was in the 2000s. So that is my timer, and I'm going to respect the time limit so that we can have time for questions.
Thank you. Oh, thank you so much. Professor Och.
Yeah, so thank you all for your presentations, particularly Ms. Howard. Thank you so much for sharing your story. It's hard to hear your experience combined with, you know, everything else that we know about how biased our legal system is against survivors, and not feel just compelled to try to do something to change it. And I hope that folks who are hearing you um, do use the authority that they have in the legislature or elsewhere to change our legal system so that what happened to you doesn't happen to anyone else. So my question has to do with the gender bias that that you all have described. So, for example, there was I think a case out of the 10th Circuit that myself and several other law professors and legal organizations signed onto a brief. I think it was a case involving a woman named Brenda Andrews. And in that case, the prosecutor made reference to her sexual history to suggest that she was guilty of the offense. And the Supreme Court, in a per curiam opinion, the U.S. Supreme Court reversed and commented on the prejudicial effect of those comments. And I'm wondering your thoughts as a panel on the sufficiency of our legal standards regarding like evidence and arguments around gender bias. We have a Racial Justice Act that allows people to come back into court even after they've been convicted, to highlight prejudicial, racist or racially biased language that even though it may not be direct, like use of animalistic language, etc. And I'm wondering, do you think the law in California sufficiently addresses the kind of biased arguments that you all have described in terms of like the perfect victim, etc.? So that's one question. And then my second question is, I guess, for David and Elizabeth. Um, to the extent that we make recommendations, and the staff has made recommendations to reform or revise the standards for self-defense to address the sort of imminence issue, is that there were other sort of components of that, but and if you haven't read it, maybe Rick or Tom, you can describe what the suggested revision is. But I'd be interested in your thoughts on whether you think that's sufficient or not. So maybe Rick, can you describe what that is, and we can get our panelists' response?
I had the same question.
So my first question is about the bias and whether there's enough direction for judges on appropriate argumentation and prejudice. And then the second is your response to our committee's suggested revision.
I can address the question on bias. And thank you for signing the amicus brief in Brenda Andrews' case. I've been involved in that case for about 6 years now. And the law is not adequate. And even the self-defense changes that you're contemplating aren't adequate in the sense that they don't affect the way the law is implemented, in the way that prosecutors can undercut evidence of self-defense by injecting these gender tropes and stereotypes. Judges are woefully uninformed about gender bias. Lawyers are really uninformed about gender bias, both defense and prosecution. And so even if you have these laws that are intended to encompass cases that truly are self-defense for survivors of IPV, it still doesn't control what happens in the courtroom and how implicit bias can prejudice the decision maker. So what happened in Brenda's case could easily happen in a case in California. There's nothing that would stop that from happening. And there are cases. There's a case of a woman who was sentenced to death. Her death sentence was commuted. She's still serving a life sentence in California, where the prosecution propped up a photograph of her naked in front of the jury. And her intimate parts were covered with money. She had taken this picture with her daughter on it was just a silly photo that she had taken, and they propped it up, they enlarged it, and they said, this is the real defendant. Like, she's sitting here in front of you, but that's not who she really is. This is who she really is. And then the entire trial was just this drumbeat of sexualized evidence about her. So there's nothing to stop that from happening. If you don't have guidelines for the prosecution and the court about biased evidence, if you don't have pathways for women to come back into court, as in Brenda Andrews' case, she now has a chance to go back into the 10th Circuit and have them reevaluate the prejudicial impact of that evidence. But the women who have experienced those techniques and who have been on the receiving end of that bias right now don't have any pathway to reconsideration of their convictions and sentences, and there's no way to prevent prosecutors from doing it in the future.
Coming just from my experience in the California courts, I am hard pressed to think of instances where I've seen a sustained objection to the use of that sort of language. I can think of one case where there was a prosecutor, engaged in some biased language around a transgender person that the Court of Appeal took seriously. And that's an unpublished case, but that's honestly about the only one I can think of in like the hundreds and hundreds of cases I've seen where this may have come up. So it's not something that I don't know how I can't speak how widespread the problem is, but in terms of how often it's actually addressed or stopped, I would say almost never. And then on the self-defense issue, was your question sort of about?
Yeah, just
please,
I guess my question was, do you think it's adequate? And maybe this is an opportunity for Rick or Tom or Joy, if you could describe what our suggested revision is.
Great.
Sure. So the staff recommendation for the self-defense section is to update the self-defense requirement statute for cases where the accused person is accused of killing their abuser. And it's to specify that a person can act in self-defense in those scenarios if the action is to prevent or escape the threat of ongoing life-threatening abuse. And so with this kind of new standard, imminence would not be a strict element that has to be proven in every case. It will be something that a jury can consider in whether the person acted reasonably. And similarly, this idea that right now it's in statute that the person has to act due to the threat of fear alone. So other, considerations like, the person was mad about the prior abuse, and that also drove them to commit the act, would eliminate the self-defense claim. But under this new standard, that would also just be something, a fact to be considered and not a strict element that has to be proven or disproven in every case.
So I want to follow up on that. Professor Sheehy, how does what Rick described as our recommendation around broad strokes map on to Canada's experience? Do you have any fine tuning that you might suggest? And related, whether this is to you, Professor Sheehy, or Rick, you mentioned that Georgia, Maryland, and I think Washington have also kind of scaled back the imminence requirement in some of these cases. And can somebody give us sort of the state of the law in these various jurisdictions and where might be the best spot? So Professor Sheehy, why don't you start?
I think that what your committee staff is proposing is a way better response than Canada's law.
You said it's better.
A better response because it refers to ongoing violence. As what the women spoke about in the prior panel, when these homicides occur, they occur in the context of cumulative abuse, where women have no idea if the next conflict is going to be fatal for her or for her kids or her friend. So I think that, capturing the language of ongoing allows for consideration of that fact that it doesn't have to be imminent. It doesn't have to be in the moment of physical conflict, because in that moment, women don't have a chance unless they have a gun. So I think your language is much better. I just wanted to also address the question about discriminatory myths being used either by judges or prosecutors. And I just want to say that we have jurisprudence in Canada that makes reliance on discriminatory myths and stereotypes an error of law. And if it's an error of law, you get a right of appeal. And so I'm just mentioning that. It's case law, it's not statutory, but we have really strong law that's used in both sexual assault prosecutions and is now being used in the context of abused women who kill in order to identify a right of appeal because a judge has relied on a discriminatory myth in their reasoning or their assessment of the facts. So I just wanted to mention that.
Okay, that's a good point. I want to pause there for a second. It makes me think about, and I at risk of opening a can of worms, the Racial Justice Act and its emphasis on implicit bias. I was wondering if any of the California folks thinks that that is a way that we might be able to address this, or is that a completely different animal?
I mean, there's been talk about, amending the RJA to include things like gender bias, which seems like sort of a logical area where this kind of reform could be affected. But
And the language in the implicit bias section and of the RJA sort of am I correct? It sort of tracks to what we're talking about.
yeah, I think so. Yeah.
I don't know if the RJA refers to intersectional bias.
I
But
don't believe it does.
It
Yeah.
does not. It's really race specific.
It has a long list of characteristics, but so I think as we'll discuss at a future meeting, actually, what exactly the RJA means and how it's being interpreted is still very much a work in progress.
But this is actually a question I had for the panelists is, as we talk about sort of the, reliance on discriminatory ideas and this notion of like the perfect victim, are you seeing non-white women being particularly disadvantaged? Because, Black women are described as more aggressive or, Latina, we can go down the list of stereotypes that might place a woman of color more outside of the trope of like the perfect victim. So I'm wondering if now that the point about intersectionality has been brought up, I think it's important for us to note. I'd be interested in your thoughts. Are there particular effects of this perfect victim trope on non-white women?
So, we are really attuned to that. And one of the challenges with previous research is that the data sets are small. So as you may know, the Black women, just to take one example, their experiences have been virtually erased from all of the major studies on racism and the application of the death penalty in this country. And there have been dozens and dozens of studies on racial bias and the application of the death penalty. And I don't know a single one that encompasses the experiences of Black women. And what the researchers will say is because the data set is too small, so you can't do empirical research that is going to withstand critical scrutiny. What we're doing now and what we're contemplating is expanding our data set to encompass women who are not currently on death row, but who have been convicted of homicide so that we can try to get a sense for what those differences might be. What we know is that historically, and we do have a couple of examples of this in our data set, that Black women have been defeminized, and that's something that we see in a lot of the transcripts, that there is an effort to demonize or other women based on physical characteristics, based on their large size, or so-called masculine behavior. And, that is something that we have seen, in particular in the case of one Black woman in Texas, where they said, this may be a woman, but she's no lady, which is something that we think is directly tied to stereotypes about Black women. So it's something that we are looking at, but it's something in my view that, again, the criminal law and the academy has really ignored this area where we have to focus because the type of discrimination that women of color are experiencing is very different from what we see, obviously, in the cases of Black men or of white women.
And I would just also, just on that point, I would also add queer women. So if you're gender nonconforming, right, how does that play into perceptions of vulnerability or, other kind of gender-based stereotypes that might affect how a fact finder, a judge, a jury is viewing the defendant?
Definitely.
To tie Professor Ocean, your question to the specific reform in the memo. One, the nice thing about having a broader reasonableness standard is it potentially encompasses a lot more factors that jurors are able to consider. The drawback of that is then it allows a lot more room for bias and how those factors are weighed and by jurors or argued, by a prosecutor. And to some extent that, that's a tension that needs to be resolved as a policy matter. But it may weigh in favor, excuse me, of having trying to develop more concrete standards for what self-defense entails, even if it goes away from the eminence standard we're currently using, such as maybe, a necessity standard, which some scholars have advocated for, which still gets into, one second, I'm sorry. Which still gets into, needing to be able to put on evidence to educate jurors about necessity in the context of IVP. But that's maybe one advantage of having a more concrete standard. And then on the other aspect, this is the fear alone. To me, that's one area where the difficulty in having jurors try to figure out, years later in a courtroom, what was going through somebody's head in addition to self-defense, whether, jealousy or anger were concurrent causes, is such a difficult and amorphous question you're asking them to answer, that it's rife for allowing bias to enter into the deliberations in that scenario. So I'm not sure if that really addresses your question, but that I think are important considerations when deciding how to reform the.
Thank you.
Certainly. I had one last question. I don't know if others have. Professor Sheehy, the Canadian self-defense law that you're discussing is not limited to IPV cases, correct? It's general.
Broad. And I like the idea that you are considering, which is, limiting it to domestic violence survivors.
I was curious, why is that advantageous than keeping it
Well,
to
well, one case, we do have one case, although it was pre-law reform, but there are men who are going to claim they killed women out of self-defense. I suppose even those cases would be encompassed by your reform. But I guess I think that the issues are quite different for survivors than they are for most other defendants who kill in confrontation. And so I do think it's more reasonable to provide an expanded self-defense for people stuck in domestic violence situations.
I see you. And Rick, the other states that I mentioned, or that you mentioned, I should say, Washington, forget what they are now. Are they specific for IPV cases, or are they general?
I think in those cases, the courts are interpreting what imminence means in their state, and they are considering IPV dynamics when deciding what should imminence mean. And they're saying that, if there's these circumstances that the person is constantly living in fear and in fatal peril, as our other panelists discussed, that their imminence shouldn't be, narrowly defined to mean the moment before the trigger was pulled, but that imminence should have kind of this broader interpretation. And I think, just to piggyback on Professor Sheehy's comment, that the Canadian court that kind of set up these reforms in Canada was recognizing that IPV dynamics are so foreign to people that don't experience them, that there should be a different consideration for those type of cases. And I think that's why the reforms could be limited to IPV cases, because these are just cases that if you haven't lived through it, perhaps you don't understand well enough.
Okay, just so I understand, the US cases, the states you're saying, have thought about imminence through the lens of IPV, but they are not necessarily limiting those to IPV cases. And certainly in Canada, they're not limited to IPV cases. Is that correct? Is that what you're saying, Rick? And
Yeah.
okay. Other questions?
Mike, I just want to see if Ms. Howard just had anything she
Oh,
wanted to
yeah.
add to the discussion, since we haven't heard from her since. Of course, if not, that's, you know, appropriate as well, but I just wanted to, you know, give her a moment if she wanted it.
The only other thing that I would like to say is that, you know, a lot of these prosecutors, the DAs, they prosecute cases for domestic violence, right? So they know all these things about domestic violence. It's not that they don't know it. It's that they use it on one side when they need that, and then they somehow conveniently forget about all that when they're using it to try to protect a survivor. And that's all I wanted to add.
I think that's very true.
And I would
Yeah,
just,
Professor Sheehy.
oh, I just wanted to add, you know, it's really a conflict of interest in those cases. How are women in that jurisdiction supposed to have any confidence that they should bring domestic violence complaints to these offices when their prosecutors are ridiculing, humiliating, shaming women who have killed in self-defense or in defense of their kids? And it's something I noticed. I've seen it myself in court. I've watched it, but I also have read it from transcripts. And we too have prosecutors who are absolutely ruthless, and who smirk, who you know, drip sarcasm when they are cross-examining women. And I'm not sure. I mean, it speaks to the misogyny, of course, and it certainly in Canadian jurisdiction speaks to racism, because many of the women who kill in our jurisdiction are Indigenous women. Not as many Black women, but Indigenous women are a big group. So, you know, the other thing I guess to think about are prosecutorial ethics, and you know, what is it we expect of prosecutors in these circumstances?
I agree. I think this does harken back a little bit to the racial justice, or the model over to the racial justice, I think. Anyway, you've given us a lot to chew on. Is there any other panelists or excuse me, committee members or staff who have any questions or thoughts? All right, I want to thank our panelists. You've given us a ton to think about. I really appreciate it. I'm sure we'll reach back out. Ms. Howard, I want to make a special thanks to you. This is a really nerdy legal conversation, and you were not brought into this. We sort of came to this voluntarily. You did not. So thank you for sharing, and everybody have a good weekend.
Thank you.
All right. I'd like to begin our second panel. Are you pulling them up, Tom?
Yes, we're actually, believe it or not, running a little bit ahead of schedule, which I've now just jinxed by saying that. But let's keep going.
Blew it.
All right, I think
Okey-doke.
we're ready to go.
I think we're all here. So our second panel is about California's coercion defense and other mechanisms for IPV to be considered in the criminal legal system. Panelists, as I mentioned before, I really try to keep this to 5-minute presentations. So I hope you just saw that our conversation is really, I feel like where the most meat gets done. So thank you all for joining us. Our panelists are Jamie Beck, who's human trafficking and domestic violence expert witness and consultant. Kate Mogulescu, is that close? All right, all right. Who's professor of clinical law at Brooklyn Law School and legal policy director of the Survivors Justice Project, and Tracy Pryor, who's chief deputy district attorney in San Diego. So, Ms. Beck, can you kick us off?
Good morning, everyone. I do have a slide deck that I am trying to share with you all. And give me
Tom,
just
is she in
one
power?
second.
You should. I mean, but if you have any issues, Jamie, let me know and we'll figure it out.
I am having issues, but I think it's a me issue. Oh, wait, there we go. Hold on. I think I got it.
Great.
Okay. Can you see my slides? There we go. All right. Thanks for your patience.
Oh, you're in presenter mode, so we
Oh,
can see your
okay.
notes. So I think you can,
Okay.
yeah, there you go. Perfect.
Okay, good. Thank you. All right. Well, thank you so much for having me here today. I'm honored to be a part of this panel, particularly since I'm alongside two colleagues who I've worked alongside since I got into this work many years ago. So I'm very grateful to be here. In my work as an expert on human trafficking and domestic violence and as a vacatur attorney, I've seen firsthand the myriad of ways that victims of human trafficking and IPV are harmed by the criminal legal system, and also the power of changes in the law to create a more just and humane response to criminal cases involving defendants who are also victims. Just to note that I will mention trafficking survivors who are deeply intersected with IPV survivors throughout my remarks. As we've talked about already today, the criminalization of survivors is shockingly pervasive. According to a study by the Veer Institute of Justice, the vast majority of women in US jails and prisons are victims of physical and sexual violence at astonishingly high rates. And as you've seen today, including the incredible Stanford research study, we've seen over and over again research confirm these data points. There's a number of common scenarios that lead to the criminalization of survivors. I'm just going to touch on them briefly. A lot of them have been talked about today, but we can talk about them more in Q&A if you'd like. One is retaliatory violence. Another is forced or coerced criminal behavior, failure to protect children, and crimes by association. We've seen a lot of incredible changes in the law in California and across the country that recognize the harms that come from criminalizing victims and aim to provide different paths for individuals within the criminal system who are both victims and offenders. In California, among other laws that we have, one is our coercion defense, which is codified under Penal Code 236.23 and 24, which in a case where a person can establish that they were coerced to commit the offense as a direct result of being a victim of human trafficking, interpersonal violence, or sexual violence at the time of offense, and that they had a reasonable fear of harm. Now, the challenges with this law are one, that it's limited to nonviolent offenses, and it also has limited applicability to victim offender cases due to the language that they have to have been coerced to commit the crime and have a reasonable fear of harm. And then there's just a lot of other challenges in asserting the defense that if we have time, we can talk about later. In addition, we have a post-conviction statute, California's vacatur statute, which allows for nonviolent arrests or convictions to be vacated where the individual was arrested for or convicted of a nonviolent offense while a victim of human trafficking, intimate partner violence, or sexual violence, and the offense was directly related to their victimization. Now, vacatur is broader than an expungement, and it actually allows for the crime or the charge to be fully removed from their criminal record, which is a pretty broad form of relief, but it also has an extremely high burden of proof of clear and convincing evidence. Very few survivors can even access this relief due to lack of access to legal services. You don't have a right to an attorney, and there's just really limited resources for post-conviction in general, and even more limited for vacatur legal services in California. So what are some opportunities to improve the laws in California? I'm going to touch on a few, and some have already been talked about today. One really important piece of improving the laws is expanding the affirmative defense and vacatur laws in California to all crimes. There actually is a pending bill right now, AB 938, which is authored by Assemblymember Bonta, which would do exactly that, and really hoping that law passes this year. In addition, there's the potential to create exceptions to felony murder and accomplice liability for intimate partner violence and human trafficking where the crime is directly related to victimization. We haven't talked as much today about felony murder and accomplice liability, but there's so many different ways in which victims are caught up in the crimes of their perpetrator, where the perpetrator may not be the victim of their crime, it's somebody else. And we really need to take that into account in cases involving those individuals as defendants. There's also a need to expand our affirmative defense, the coercion defense that I mentioned, to broader language that rather than saying that the individual is coerced to commit the crime, that the crime occurred as a direct result of being a victim. And that would mirror our vacatur law, and it would also mirror laws in other places. For example, Wisconsin has a human trafficking affirmative defense that has that language in it and applies to all crimes. Potentially recognizing a separate survival homicide offense, and there's really fascinating literature on that for victims of IPV and human trafficking. And finally, and in some ways most importantly, to entirely shift the response that we have to these individuals to non-carceral penalties that really focus on mental health treatment for victims. This is not a dangerous population. This is a population that if they get treatment for the trauma they have endured, they are not likely to reoffend. They are not a danger to society. And not only are we harming them, but we're harming their families, their children, and their communities when we lock them up, and creating generational trauma that we could completely avoid if we shift to non-carceral penalties. Thank you so much.
Thank you very much. Ms. Mogulescu, can you correct my pronunciation?
You did a great job. I'm Kate Mogulescu. I'm a professor of clinical law at Brooklyn Law School, and I'm also the legal and policy director of the Survivors Justice Project, which is a collective in New York that has been working on implementation of the Domestic Violence Survivors Justice Act, a sentencing reform, since it was enacted in 2019. And I was off camera for the meeting thus far, but had I been on camera, you would have seen me vigorously nodding at a lot of points in the prior presentations. So many different threads going at the same time here. And our work in New York around the DVSJA, that's the acronym for the Domestic Violence Survivors Justice Act, sort of pulls in a lot of different pieces of what has already been discussed today. Like Professor Rummel, I also love the Fatal Peril Report. I think it brings to the surface some of the complexity and why this memo and this meeting today covers so many different potential intervention points in the criminal legal system, and why it has to. It actually has to. And so I would love to just respond to a few different things, give an overview of the DVSJA work we've been doing in New York, and then allow plenty of time for questions. But the Domestic Violence Survivors Justice Act, which was passed in 2019, it was fought for, campaigned for over 10 years in New York, in a campaign that was led by currently and formerly incarcerated women, many of whom were survivors of violence. Our efforts to implement the law since it was enacted have tracked the campaign's philosophy and approach and principles, in that people who are most impacted both by extreme sentencing and by domestic violence have to be leading the implementation efforts, just like they led the campaign for the law. So our Survivors Justice Project Collective is exactly that. And one of the things that we have been doing is gathering data, tracking the law's impact since it was enacted, because our court system and government in New York have not committed to doing that, which leads me to my first point. Wherever you land on all of these proposals, or with respect to existing law in California, data collection is one of the most important things that we can do. We need to be able to understand what's happening, what's missing. And so there were some points already made about some of the limitations of research in this area, but just simply prevalence of use of all of these laws is critical. That is one thing that the Survivors Justice Project has tried to do. The DVSJA has two pieces to it. It is a sentencing reform. Let me just be very clear about that. So with all this discussion about changing definitions in terms of self-defense or coercion, the DVSJA is a sentencing reform that says if you are a survivor of substantial domestic violence, not just intimate partner violence, and your offense, that domestic violence is a significant contributing factor. That's the language we use, a significant contributing factor to the offense you commit, you may be eligible for an alternate sentencing framework. The DVSJA has a resentencing provision, which allows survivors who were prosecuted for offenses committed before the law went into effect to go back into court and seek resentencing. For survivors who commit offenses after the law's enactment, they must raise the DVSJ at the time of sentencing, which is one of the issues that we are seeing in New York, one of the obstacles that we're seeing in terms of survivors actually getting meaningful relief under the law. We've been looking at the resentencing portion to understand a little bit about how this will travel throughout New York State and impact folks. Since the law was enacted, 74 people have been resentenced after filing DVSJ resentencing applications. So again, that's the group whose offenses were committed before the law went into effect in 2019. That includes 66 women and 8 men. The resentencings eliminated 19 indeterminate life sentences, those 74 people. In terms of the racial breakdown, 74% of the 74 people, coincidentally, 74 and 74, are people of color. I mentioned at the beginning that the DVSJ applies to domestic violence more broadly than simply intimate partner violence. So the DVSJ recognizes family violence as well as intimate partner abuse. And in 9 of those 74 cases, survivors had experienced severe parental abuse. I think the way this might all tie together, particularly for this panel, is the law recognizes that the person harmed in an offense that a survivor commits does not need to be the abuser. And so in approximately half of the successful resentencing cases we have seen in New York, we have what we call a third-party victim, or someone who was harmed in the offense who was not the abuser. And so we can talk a little bit more about the situations we're seeing there. Altogether, these resentencings have saved over 200 years from what would have been this group's earliest possible release from prison. But if they had been sentenced under this framework to begin with, it would have avoided close to 557 years of prison. And that is, again, just for the 74 people who have been granted sentence reductions so far. I think I'm probably already out of time. Yeah. So I will be happy to take questions, but to Professor Osen's questions before about traumatic brain injury and involuntary manslaughter or extreme emotional disturbance, I would add to the consideration of TBI also something that we've seen as another sort of intersection point for many of the survivors that we work with, which is postpartum mental health disorders, and how those also are absolutely overlooked, ignored, misunderstood in the very, very male-oriented evaluation of mental state that goes into homicide prosecutions and case adjudication. I will leave it there, but really do welcome any questions at all.
Thank you. We'll definitely get back to you. Ms. Pryor.
Thank you so much. I'm honored to be here today among my panelist colleagues and the great work that you've all done in your careers on this call. And thank you for offering and listening to a perspective from a prosecutor, which may be a little bit different than some of the discussions here today. And I appreciate that. I've been a prosecutor 29 years. Most of my career has been trying to stand up best and show up best for survivors of abuse in the domestic violence context. I'm a chief operating officer of a family justice center, which is a co-located one-stop victim service hub that is rooted in ACEs and is trying to swim upstream to prevent survivors becoming defendants. I wanted to just mention a little bit about the slowing down process that often happens when a female is presented in our caseloads. And I just share that because seeds that I've heard today are importance of training, and I absolutely agree with that. Having people that are in the prosecutorial world that are specially trained in domestic violence, like 273.8 codified, is critical. And just, that's a perspective that I think sometimes the data can't capture, is how many of the cases weren't charged at all, or how many of the cases came submitted to a prosecutorial office where 13701 was enacted so that law enforcement can consider these kind of factors. That's one of the suggestions I might make today to the committee, is to take a look at 13701, which is the laundry list of the dominant aggressor factors, and adding in including strangulation or traumatic brain injury to that analysis for law enforcement officers to thoughtfully and measuredly look at who they're arresting, because a survivor defendant, it starts with an arrest. And so I think that's one way to swim upstream. One of the things that we've learned as prosecutors, our county, for instance, has a non-lethal strangulation protocol. And that's because two abuse-related pathways, critical ones, are strangulation and firearms. We know from looking at data from all of our intimate partner homicides that firearms are by far the number one, and then stabbings, but then strangulation by about 13%. That is an ugly truth, is strangulation, about intimate partner violence. And obviously, one of the big issues is underreporting. For our Family Justice Center, 7,500 survivors have walked in, and only 13% of those people have reported abuse to the police. And many have indicated it took a long time to do so, partly because some of them feel that if I do report, nothing's going to happen. They feel that they can't escape, so they remain in harm's way, endure until it gets so dire that they choose to take the law into their own hands. And this is ripe with risk, and results in what the Stanford report, which I was honored to be in the room and be a part of in a think tank, aptly titled The Fatal Peril. So just a couple ideas that I was thinking of here is to talk about that ugly truth and really look at strangulation, which luckily in California, a great start was the Diana Gonzalez Strangulation Prevention Act, adding that word to 273.5. This was a great start. But in the 13 years since strangulation made its way into our California Penal Code, we've learned even more about the prevalence and the dangers of this highly lethal form of violence. In Stanford's Fatal Peril report, for instance, almost 60% of people serving life in the state prison, women, for murdering their abusers, reported previously being strangled by a partner, and 8% of those strangled more than once had passed out or suffered symptoms to TBI. So in our perspective here, mine is to evolve that discussion a little bit about strangulation can kill. People v. Reed came out in 2025, recently talking about those extra hurdles that have to be proven for strangulation. That came down and said that strangulation is a traumatic condition and corporal injury. And that was the message, is that strangulation is felonious, and we want these survivors to have some sort of accountability so that they can have time to get safe or go to a family justice center, receive services, so that they can try to find a way to escape. Strangulation is something to think about. 13701B, that dominant aggressor rule, that could add in this language of including strangulation or traumatic brain injury when officers are making that determination. We need to be better as an entire system about training on both these areas. So that's something that our county, after we launched a strangulation protocol for law enforcement 7 years ago, we looked at the data. Did it reduce the DV homicides generally, and did it reduce strangulation as a method? And we found that those numbers are going in the right direction. So much more training around that. And then I guess lastly, just to think about these survivors that feel like if they do report, nothing's going to happen. There are a lot of defendants that linger in what I'll call kind of the misdemeanor land, where a survivor feels like nothing's going to happen. And so something about thinking through the habitual misdemeanors that, keep doing a TRO violation or keep hovering in the land of, maybe not leaving an injury, because strangulation doesn't leave an injury, and thinking about how to hold those individuals better to account. I just want to end by saying that, it's an honor to be here and have our perspective, or my perspective, personal perspective, shared. And there's so much work still to be done. But these family justice centers that this Penal Code Committee codified, 13750, is a gold standard for the nation. There are 150 of these centers now in 15 different countries, and everybody looks to California Penal Code that has a codified code that says the importance of these centers that are rooted in ACEs and can help swim upstream so that a survivor does not need to take the law into their own hands. Thank you.
Thank you all very much. I have a bunch of questions. Professor Ochin, why don't you kick them off?
Yeah, I wanted to lift up something that Jamie mentioned during during her presentation. The last one of the sort of areas that you pointed to was non-carceral interventions. And I raised that because, I think it would have been great if we would have been able to hear directly from a service provider who works with people who have experienced intimate partner or domestic violence. Because one of the things that in working with organizations, and I want to shout out the Genesee Center, which is based here in South Los Angeles, and they work predominantly with Black and Latina women. What I hear from them, and I'd be interested in hearing from the panelists as well, is that their clients don't simply want, when we're talking about, swimming upstream, and I appreciate that framework, Tracy, their clients don't just want a criminal intervention. They want the violence to stop, but they may want repair in their family, or they may want support with, finding another place to live, or, finding support for themselves. I mean, when you overlay this with things that are well beyond the scope of our committee, I understand, right? But if you think about, a survivor wanting to leave or to get some separation from the person that's abusing them, and you overlay that with the amount of, say, wealth that Black women have, which is negative $100 on average, right? So there are a lot of other factors here that play a role in the susceptibility of someone to experiencing intimate partner or domestic violence that are beyond the scope of our committee. But I do want to emphasize that I think we should be talking also about community-based, non-carceral responses to support survivors earlier, before there is some kind of a use of violence in self-defense or some kind of a confrontation. And so I just wanted to underscore that. And if Jamie, if you wanted to add anything to those comments, I'd be interested in hearing them. And I think the committee would benefit from it.
I really appreciate those comments and couldn't agree more. In this moment that we are in, funds for those services are getting demolished, and it is going to be a lot harder. It's going to be a lot harder for those individuals doing that incredible work to continue to do this work. They're already having to cut staff and services because of the federal cuts that are happening across the board. So I think it is so important to highlight that need. And I know California has backfilled VOCA funds, which has been extremely important to preserving those services. But and one other thing I'll highlight is what you said about what victims want with respect to their offenders. A really incredible book, Truth and Repair by Judith Herman, the entire book talks about that. And it really talks about most victims and survivors aren't looking for carceral punishment for their perpetrators. They want an acknowledgement of the harm. They want the harm to stop. They want the community to acknowledge their harm, and talks a lot about restorative justice and alternative pathways to really resolve these issues. But we need to get at the root causes that lead somebody to engage in any type of violence, and in all the contexts that we're talking about. And locking people up is not solving this problem at all.
Yeah, so I think on that point, I don't, in my limited experience on the committee, I think we have talked about restorative justice. And I think this would be a place to kind of, to the extent that we're serious about kind of advising the state legislature on areas where we can expand restorative justice programs and models. This has been an area where there have been studies that have shown restorative justice can work. And as we're thinking about the hesitancy of survivors to call law enforcement, because they're worried that they might be harmed, right? There have been instances where, Black women have called the police for help, and they're the ones that end up investigated. They're the ones that end up losing their children to CPS, or they're the ones that end up killed. So I think it's important to remember that, the folks that we're asking to trust us, us being the system, you know, to help are folks who have disproportionately experienced harm from the systems that we are pointing to as avenues for support. So, you know, and we can overlay that with what's happening with immigration in the state. And so if you have, you know, folks who have a mixed status household, or they may not have, you know, they may not be documented. And we know now that even an arrest can put someone in a pipeline for deportation. So, you know, I think if we're serious again about prevention and giving folks options, then we do need to think about non-carceral interventions that can stop the harm without further criminalizing families and communities, and putting them on the pathway to potential deportation or further harm.
If I could just also offer,
Please.
I mean, I agree with that completely. And I think we sometimes feel constrained, right? This is the Committee on the Revision of the Penal Code. And what does the Penal Code look like that has some of these principles embedded in it? I would love to see that. I mean, some of us just feel so entrenched in the current criminal legal system as it operates, it's hard to imagine, but there is possibility. One of the things that we've seen with the sentencing reform in New York, even though a sentencing reform is not restorative justice necessarily, but when you change the way you speak about people and their experiences and the potential sentences they're facing or have faced, and you are able to, right, to reframe, there is healing that comes with that. And we've seen it in sort of surprising ways in New York in the implementation of this law, where particularly in the post-conviction context, you're bringing together then people, families that were harmed by violence for years, and then maybe one particularly serious offense like a homicide, and the ability to revisit and sort of allow for nuance and complexity, where in the original adjudication of the case that never happens. It's simply not allowed. There is something there. So there are ways in which these different intervention points are expressive, right? And then may lead to some of the type of work that we need to do to actually create real opportunity for the upstream, the preventive, the things we all know to be true, but sometimes have a hard time figuring out how it fits into a penal code or a criminal procedure law.
So I think that if it wasn't our very first meeting, it was certainly very early on that we, tried to wade into the restorative justice field. But it's been a while, so I think that we should maybe consider revisiting the issue and seeing if there are updates and developments elsewhere around the country. I had a couple of questions for Ms. Pryor. First of all, I wanted to say that my understanding is that DA Steffens, excuse me, DA Steffens, has taken a real leadership in gender-based violence and domestic violence in particular. And so I think that your office has a reputation of being leader in this field. And I was curious, I don't know if you were listening to the prior panelists or prior discussion of your reactions to a couple of proposals that are probably what I'm going to characterize as defense side proposals. Particularly around changes to self-defense and the use of misogynistic language or tropes or bias by prosecutions. And I don't want to rehash the territory if you've already are familiar with the issues, but I was wondering if you had reactions to those two issues and proposals.
Thank you, Chairman, and obviously my elected official, Summer Steffen, she's worked her career in the space as well. And although I don't, speak for her, I did get a chance to read the recommendations, and on the self-defense piece, it's I don't know if it needs to go that far, and I guess the reason is that I think that 1107 and Humphrey and the robust aspect of 1107 that the evidence has a pathway into the case. When I'm as a prosecutor, I'm just spitballing this piece, but if I'm at a point where I'm seeing 1107 imminence, again, I hope that people can recognize that the process obviously can get way slowed down where that case is in the system. But if that case is in the system, I think that being able to have 1107 evidence introduced that it is enough So I'm not ready to say, yes, we have to change the definition. If ongoing life-threatening domestic abuse is part of that definition, I might qualify the ongoing with something like current. I think sometimes a prosecutor might worry that somebody's going to say, I was a domestic violence victim, many, many, many years ago. And then I premeditated and deliberated and, conspired to kill somebody. But I think the definition's going in the right direction to be supportive of IPV survivors. The second part, you asked about, Chairman, is coercion defense? No.
No, excuse me.
the-
Well, before we get on to that, because I do want to so I understand your position, is the 1107 evidence you think is sufficient that it essentially expands the idea of imminence if you can introduce the enough evidence and educate juries, judges about IPV, that will implicitly expand the idea of imminence without necessarily changing the definition altogether. I just want to make sure I understand that that's what you're saying.
Yes, that's a pathway in for all of that evidence. I mean, I've seen
Right.
11, we just don't do that many things and murders, but that's a pathway forward.
Got it. My other question was, one of the other panels focused on misogynistic tropes that are sometimes used against women defendants, and the suggestion that should be, I guess, prohibited. And I was wondering if you had thoughts about that.
We never want to use misogynistic tropes against people. I mean, I think language that is, against and abhorring.
I didn't mean
any
to say, are you
violence.
pro misogyny? I didn't mean to
Oh.
suggest, but okay, but do you understand what they're getting at, and that sometimes that
Yes, I do. And that's why I'm so, practicing as a prosecutor in this state where specialized training is important and it's codified in the penal code that specially trained prosecutors should be doing these cases. But just, in general, absolutely. I mean, I'm supportive of that.
Good. Thank you. And I will say, I really do appreciate, we make a big effort to include as many different voices as possible. I think that rightly or wrongly, our committee has a reputation for making a lot of recommendations that are perhaps defense friendly, but we always include perspectives from prosecutors, and it's really important to hear from that, and particularly where we find common ground, where there are issues in the justice system where we think we can do better for everybody. So thank you. I want to say especially thank you for joining us. Other questions from staff or committee members?
I have a question for Jamie and Kate. Jamie, you mentioned some specific reforms to the coercion affirmative defense language, I think particularly around that first bit that says the offense was the result of coercion. And I just wanted to bring that up again about why you think that's important, and if the current bill from Assemblymember Bonta changes that at all, and then what other practical changes to the statute would you suggest at this time?
Thanks so much for the question. So the current Assemblymember Bonta bill does not change that language. The only thing it changes for the affirmative defense is to expand it to all crimes. All crimes, right now it's all crimes except murder, but then there's a carve out for felony murder. So almost all crimes, I'll just say that. So, and having worked with survivors as on an expert witness basis on cases involving this exact scenario of victim offenders, I see in many of the cases that I see, survivors aren't eligible for the affirmative defense for many reasons. One is the limitation of the types of crimes that are eligible, but another is this language of I was coerced to commit the crime and I was I felt like I was in danger. And the reality is that there's all types of situations where victims engage in criminal behavior that is directly related to their victimization. It is I think the language in New York was substantial. What was the language, Kate? Substantial factor? Is that right?
Significant contributing factor.
Significant contributing factor. Like that is a very different way of looking at these scenarios that come up. And I mentioned things like accomplice liability, forced criminality, felony murder. Those three kind of types of cases are situations where somebody, the entire reason they are in this situation has to do with their victimization. But oftentimes it doesn't even come into play in their case because it's not seen as relevant of what is their relationship with their co-defendant. What was happening in their life that brought them into this situation where they committed a crime or where they allegedly commit a crime. And there's a lot to talk about with forced criminality and accomplice liability, but there's also a ton of research on those particular issues and how it comes to be that somebody is a victim who is engaged in criminal behavior because of their victimization. And Kate, please add anything I missed.
I agree, Jamie. And I think, Rick, when we've talked about this and thinking about it, the two major obstacles embedded, I think, in the existing defense are, one, the exclusion of violent felonies, which just, it's too big a barrier for too many survivors. And even just looking at the Domestic Violence Survivors Justice Act in New York, which applies to almost all violent felony offenses in New York State. It excludes murder one, sex offenses, and terrorism offenses. Just sort of using that as a way to see all the possible extensions of these kinds of laws that are meant to identify situations where the domestic violence someone's experiences and their participation in an offense are really just so connected that you can't tease them apart. But statutes like coercion, duress require things, and self-defense, as you were all talking about earlier. I think we're too conditioned to see and read imminence into that in a way that survivors experience in their relationships and with harm just doesn't track. So there are a few different things there. One is the offense exclusions, which that would be my number one suggestion, is to eliminate those. Also, why should someone be able to, like if we're thinking that someone is committing an offense because of their experience as a survivor, it just doesn't track that there are certain offenses that would be eligible and certain that wouldn't, if we're really bringing it all back and rooting it in their experience with domestic violence. And yeah, the direct result, coerced to commit the offense as a direct result, I don't know. You all have done a much deeper dive here, but I imagine courts struggle with that and struggle to apply that as well. And so thinking about changing language to, again, reflect the experience of survivors as we understand it and what we've seen. Significant contributing factors, what we have for the DVSJ in New York. I'm not necessarily even pointing to that as the solution here, because several states that either have pending sentencing reform bills for survivors or have already enacted sentencing reforms for survivors, like Oklahoma and now Georgia, even go so far as to say contributing factor. And that's sentence reform. It's different than a defense. I understand that, but we really have to think about just what this language is conveying and how it aligns with the experience of survivors.
This has all been super helpful. Thank you all. Do any of the other members or staff have questions? All right. Thank you. I like to say no good deed goes unpunished. I'm sure we'll be in touch with you. Thank you so much. We're going to talk about after lunch where we're going to kind of proceeding with recommendations. Those of you who are not super familiar with the way that our committee works, though, our recommendations won't be finalized until around Thanksgiving time. So between now and then, I'm sure we'll be in touch, and you please don't hesitate to be in touch with us as we refine our thinking about these issues. So thank you all for joining us. And we're gonna have one more presentation before lunch.
And we're still waiting. I think we're a little bit ahead of schedule. So I think our final presenter, Justin Dews, will be here very soon.
All right. So let's take 5 minutes and get back at 11:55, and hopefully Mr. Dews will be here.